Good afternoon, everyone. Thank you very much for joining us today for Park Lane Plowden's employment law with lunch session. I'm not called Park Lane Plowden, I'm Robert Dunn, one of the hosts today, and with me I have Amy Rumble as well. We're both employment law barristers at Park Lane Plowden Chambers. Thank you again for joining. It's much appreciated, and I hope it's a useful time for all of us. Now, I'm going to share my screen now, so goodbye for the moment. The topic today, we've given it a slightly snappy name because jurisdiction and giving evidence from abroad in the employment tribunal wasn't as much so. We are going to look at a number of points of jurisdiction and also the practicalities of giving evidence from abroad and some consequences that may apply and some things that may need to be thought through if that is going to be a feature of an employment tribunal case. In terms of ourselves, there's a brief bit of background about both of us. Both 5 years call, both do a huge amount of employment work for claimants and respondents. There's links there to our profiles. So what are we going to look at today? That is a picture, unfortunately, not from one of my cases or Amy's, as far as I'm aware, but you may have all had cases where witnesses have dabbled with provision of evidence in a similar manner to this gentleman. I'm going to do the three probably duller elements of the talk, essentially the background as to jurisdiction of the tribunal, choice of law, or which law is appropriate, and also finally which employment law rights might be applicable in terms of their territorial reach, and then Amy's going to finish off with the most interesting bit for the second half. So first of all, what about jurisdiction? If you are bringing a claim within the employment tribunal, or of course within the county courts or even the High Court, you need to make sure that you have jurisdiction. You can bring the claim essentially against often the employer as an employee, or of course you need to make sure if you are the employer that whichever tribunal is purportedly having jurisdiction over you actually has the ability to do that. Usually it's of course not an issue because someone works in England, employers obviously based in England, it never really comes up. But there are times when it of course does. So firstly, we look at the issue of forum. Now, prior to Brexit and the end of the transition period, the Brussels I regulation applied. So the main rule was Rule 1, persons domiciled in a member state shall, whatever their nationality, be sued in courts of that member state. But that rule was different for the situation of an employer and employee, because it did allow an employer to be sued somewhere else. For example, we see 21B there, in the courts of the place from where the employee habitually carried out their work, or in the last place they did so. So there were some exceptions to that. That applied for proceedings that were commenced before the 31st of December 2020. The regulation no longer applies, there was an attempt by the UK to join the Lugano Convention, which is a convention from 2007, which has very similar rules to this, and it does apply outside the scope of the EU. It, for example, applies to Iceland, Switzerland, sort of EFTA nations. But as I understand it, despite the EFTA nations agreeing to it, the EU have essentially blocked the UK joining that. So we're not going to go back to a position where we're in an international convention such as Lugano, where the same rules as the Brussels regulation apply. So we are now in the snappily named jurisdiction of the Civil Jurisdiction and Judgments Amendment EU Regulations 2019. So this sets out essentially where, not necessarily just for employment tribunals, but it sets out where employers can be sued. And it does, to some extent, seek to try and duplicate the rules that were there under the Brussels regulation. The employer could be sued by the employee, whether the employer is domiciled in the UK, in the courts for the part of the United Kingdom in which they're domiciled, the place where the employee habitually carries out the employee's work or last did so. So that duplicates a lot of what we looked at in the Brussels section. Or there's an exception if the employee does not or did not carry out their work in any part of the United Kingdom in the courts of the place in the United Kingdom where the big business which engaged the employee is or was situated. So we're in a situation where, speaking generally, the rules have sought to duplicate what the position was before Brexit, but of course the rules now do come from a very different place. In terms of tribunals themselves, the key provision that tribunals will look at, we're considering this, is Rule 8 of the Employment Tribunal rules. We've had some nice pictures so far of Brussels, so I thought I'd have a beautiful picture from England and Wales, of course, the great city of Newcastle. Now, in terms of Rule 8, the claim can be presented if essentially any of these four situations apply. So the respondent resides or carries on business in England and Wales. That's usually treated for residing as essentially the central management or control of the business being based in England and Wales. If one of the acts or omissions of the employer took place in England or Wales, so for example, if you were an employer that was choosing to dismiss people who were working in England and Wales, you might try and get out of that by dismissing them from abroad. That might be something that perhaps was in consideration of P&O, if that was indeed an issue for them. But we also see that if the claim relates to a contract under which the work has been performed partly in England or Wales, so if that applies, that might allow the employer to be brought within the tribunal's jurisdiction. But then also this very vague question, which I'll sort of touch on a bit later, where the tribunal has jurisdiction to determine the claim by virtue of a connection with Great Britain, and the connection is at least partly a connection with England and Wales. So there's a number of factors the tribunal will consider, which I'll come on to later, but it's essentially a very widely interpreted section, which does allow the tribunal to potentially extend its jurisdiction, put it that way, when you have essentially a respondent from outside England doing things outside England that might impact employees who don't necessarily work in England, but maybe have some sort of connection with them. I've put two cases at the bottom, which are cases maybe just worth noting. The first one is the case of Conan Bazwinski, a EAT case. And the key ratio of that case is essentially that this is a different question to whether the employment rights actually apply to the situation. So Lawson and Serco and the cases around that, which I'll come on to in a moment, that's about the scope of the rights. But this question here, although very similar, is about whether you can actually bring the claim against the employer within England and Wales. And in that case, essentially, the tribunal all treated it as the same thing. They said, look, it's pretty much the same thing. And the EEAT said, well, no, it's not. They're two different questions. You have to consider them separately. The second case, the Pervez case, which is a matter from the EAT, where again the EAT said essentially that they will interpret the rules proposedly or rather widely to try and protect employees when they can. So that's maybe something to be aware of with regard to interpretation. Second point, which I'll deal with very briefly, choice of law. Usually not an issue, I imagine, in most of the cases you will have, but it is worth considering what law applies. The Rome 1 regulation still applies post Brexit. Different position to that with Brussels. The primary position, it's essentially all in those four provisions in Article 8. So point 1 is, look, it's the law chosen between the parties that applies. But if it hasn't been chosen by the parties, you look at where the employee habitually carried out their work in performance of the contract. And if you can't work that out, or it's unclear, you can go to point 3, essentially where the place of business through which the employee was engaged is. And lastly, you can look at, if you can't tell from all of those things, which country's law is most closely connected with the circumstances of the situation or the contract. The key question that usually arises is essentially whether the specific rights actually apply. So even if you've got an employer who you can bring a claim against under those Rule 8 rules within the tribunal, you've got maybe English choice of law as well, or the rules say that English law applies. How do you get to a situation, or how do you know whether, for example, the Employment Rights Act, the Equality Act, how do you know whether they actually apply or not? And the key case, you'll probably all be familiar with it, is the House of Lords case of Lawson and Serco. And Lord Hoffman gave the main judgment, and he was focusing on the Employment Rights Act 1996. And there were 3 cases there, which were all relatively niche in nature, as you'd expect. And the facts are exactly what you don't want to see in an ET1 if you're a respondent and trying to deal with a response relatively quickly. All sorts going on. The gentleman, Mr. Lawson, working as a security supervisor on Ascension Island, looks beautiful there in the South Atlantic. It's a dependency of the British Overseas Territory, companies based in the UK but providing worldwide services. So there's a lot going on there. And essentially the tribunal, and then the Court of Appeal, then the House of Lords, had to decide whether the Employment Rights Act, most importantly unfair dismissal, but there's a number of other rights, of course, that come with that, whether they apply. And Lord Hoffman, there he is, set out essentially the number 1, the general rule was that if you're working in Great Britain at the time of dismissal, you could claim unfair dismissal, so the ERA would apply. But But he then set out essentially two exceptions to that. One was if you were what he called a peripatetic employee. For example, the pilots, in the case of Crofts and Vita, where you weren't strictly maybe working in Great Britain because you were flying around, but you had a base where you regularly came to and from, they would be covered. And then we also had expatriate employees. For example, you are working for a British employer, but abroad almost the whole time. So, for example, the BBC's correspondents, for example, foreign correspondents working abroad, reporting on incidents that happen abroad, they may never really come to Britain, but they would be potentially included under that because they'd be posted abroad by that British employer for the purposes of that British business. Or, for example, if you were working within an extraterritorial British enclave in a foreign country, so perhaps if you were in a British Army base, for example. So that was the start point. Lord Hoffman said, look, it's not exhaustive. And that then led to these essentially two further cases. So there's Rabbit and Halliburton, and Dunscombe and Secretary of State for Children, Schools and Families, both Supreme Court cases. Rabbit and Halliburton, again, a bit of a nightmare to see in an ET1. Claimant lived in Great Britain. He travelled to Libya, where he worked for 28 days at a time for a company that was based in Aberdeen. Almost all of his work was abroad. And the tribunal, essentially when it got to the Supreme Court, Lord Hope said that the question you should be asking in those peripatetic cases, so where someone's based, maybe based in the UK, but they do almost all their work abroad and Britain's just a base. The question is whether the connection with Great Britain and British employment law is sufficiently strong to enable for it to be said that Parliament would have regarded it as appropriate. So they're not entirely clear, rather vague. And then with expatriate cases, the case of Dunscombe, Lady Hale said, well, in those cases, the sort of foreign correspondent example I gave before, where an employee works and lives wholly abroad, it's more appropriate to ask whether his or her employment relationship has much stronger connections with both Great Britain and British employment law than with other systems of law. So what might have been a bit clearer in the case of Lawson and Circa, we then have these two cases, Rabat and Dunscombe, which give rather vague tests to us, the idea of it being sufficiently strong connection or much stronger connections with Great Britain. And what that's essentially led to is the tribunals considering numerous factors to try and work out whether that connection's sufficiently strong. Key factors will include, for example, what currency people are paid in, whether tax and national insurance are applied in England, the law of the contract, perhaps, the pension situation and the pension system, where HR might be based, even in some cases where the person's home is, or what they'd call their home, and also their nationality, which you might not seem hugely important either, but they're all factors the tribunal will consider. And what this allows the tribunal to do is take essentially a very wide interpretation, apply all these facts and allow them to, if they wish, give employment rights to people who might work for a company that is not necessarily even based in Britain. They might do the vast majority of their work abroad, if not all of it. But those factors can still allow a tribunal to say that employment rights under the ERA do apply. Notably, these are, of course, only rights under the Employment Rights Act. But the general position seems to be, and this is from the explanatory notes to the Equality Act, that essentially the other rights that we might have in employment law or commonly deal with, such as under the Equality Act, seem to be essentially interpreted under these rules as well. The key case, for example, Court of Appeal case of Bates van Winkelhoff and Clyde and Co. The Court of Appeal essentially just proceeded on the basis that it was the same. They said, look, if someone wants to come and argue that it's different, then you can come and make that argument. But until we hear otherwise, we'll essentially assume it's the same. There could be an argument on that basis, and one could maybe say, well, because the Equality Act, a lot of those rights stem from EU law, there's a principle of effectiveness there, and therefore these rules have to be interpreted differently, and it should be maybe even wider than it is within the Employment Rights Act. But then on the other side, there's an argument that, well, post-Brexit, does the principle of effectiveness even apply to interpretation of those rights under the Equality Act? So could be a very muddy area if that is an argument that is to be raised. But at the moment, it does seem that the Equality Act and most employment law rights will take steer from what was said in Dunscombe, in Ravett, and in Lawson and Serco. So that's hopefully a rather thorough summary of those 3 points. I'm going to hand over to Amy now, who's going to hopefully deal with something more interesting.
Thank you very much, Rob. Good afternoon, everyone. I hope you're all having a good lunch. We're going to move on to deal with a slightly more practical topic in terms of witnesses giving their evidence in tribunal, and particularly in the context of what location they might be in. I might just quickly try and see if I can effectively share my screen so that I can release Rob of his duties of clicking through the slides. So bear with me one moment. Hopefully you can all see the screen.
Yeah,
brilliant. Yes, so as outlined, we're going to be looking and having a brief overview of witnesses giving their evidence in tribunal, and with a particular focus of witnesses being abroad when they give evidence. We're going to look through the principles and requirements that we may need to follow if our witnesses are giving evidence from abroad in the employment tribunal. We'll also have a quick look at what the provisions are and requirements are in other civil courts and tribunals, and then back to looking at the future expectations and what we could expect the employment tribunals to require of us if our witnesses are giving evidence from abroad in the future. So what we've seen is our witnesses give their evidence from places such as the office and home, which might be expected in light of and following the pandemic. But we're also starting to see witnesses give evidence from more unusual places, such as their car, as I had in a recent case, despite contrary advice as to why that may not be appropriate. But what's been of particular notice in our remote hearings is when we have a situation whereby a witness may be abroad, whether that be on business or holiday, and want to still participate in the hearing. And what's been noticed in employment tribunal is more often than not, there isn't a consideration necessarily given at the outset of the hearing, either from the parties or the judge, as to whether that's appropriate, whether proper permission's been sought to allow that, or indeed whether that is required. So having a particular look at how we may expect to deal with that. Well, the starting point is, of course, the Employment Tribunal rules and procedure, and that being going back to basics of the overriding objective. So, of course, what that says is we should be dealing with cases proportionately, seek flexibility in proceedings, avoid delay and save expense. So taking into account those principles, you'd be well-minded and a good starting point in arguing that just because your witness is abroad shouldn't prevent the hearing from going ahead as planned. What we also have in the rules of procedure is, particularly in relation to Schedule 1, rules 46 and 32. 46 being the starting point for giving the tribunal the power to conduct the hearing by electronic means. And the two requirements that are set out in doing that are it's suitable as long as essentially the tribunal can hear the witness and the witness can be heard, and the witness can hear the tribunal, and see the witness, and the witness can see the tribunal. So that's quite a widely drafted provision. It's not necessarily prescriptive, but of course those two requirements could easily be met even if your witness is in another location. But interestingly, in Rule 32, what we have is the provision whereby the tribunal is expressly limited in terms of ordering a witness who is outside of the UK to attend and give evidence in tribunals, so that they don't have the power to order a witness who's abroad to give evidence. But other than that, the tribunal procedure rules are quite silent on the point, which is in somewhat contradiction to other areas of law and other courts and tribunals in the UK. So particularly looking at the civil procedural rules and in the civil courts, Rule 32 expressly addresses the need to ensure that permission is sought, or that there's an understanding that the country from which the individual is giving evidence from hasn't raised objection to them doing so. And this is also derived in other areas of law and international law, and there's reference often in case law we see to the Hague Convention and what that requires. So there's a requirement on individuals in other areas of law, giving evidence in other tribunals and courts, to make advance inquiries and inform the court of what those inquiries are and the outcome of the inquiries. We've not quite seen that enforced or implemented as such in that way in tribunal, but this simply essentially seems to be a silence on the subject. And this has created a bit of a gap, if you like, or a lacuna in that, well, how does the Employment Tribunal deal with the recent guidance that's been given to other courts and tribunals? The recent case, and I'm bound to pronounce this wrong, so do excuse me, but of Agi Babiaka, addressed in this topic and gave some guidance. It was a first-tier tribunal case, and in that case, the individual was giving evidence from a base in Nigeria, but they hadn't demonstrated that there was an agreement or a discussion in place and permission given in place for the individual to give evidence from Nigeria. As a result of this, they said that was in contravention with the requirements that we've just seen in the civil procedure rules, but also the Hague Convention. And there was guidance given going forward from that in November 2021, whereby the Foreign, Commonwealth and Development Office would be setting up and establishing a particular unit, that being the taking of evidence unit, specifically set out in terms of being for administrative tribunals, but again, it's not necessarily limited to administrative tribunals. So in terms of what we see the guidance setting out and what that unit sets out, is that it sets out that permission from a foreign state is necessary before oral evidence can be taken from a witness in that state for the purposes of a court or tribunal in the UK. So in any given case where a party wishes to rely on evidence from abroad, they are responsible for ensuring that permission has been given by the foreign state. Any requests for permission should be made, and the party who's intending to give evidence from the foreign state should take steps to make sure those assurances have been given. And that leads us on to this process, which is set out on the Gov.uk website about giving evidence via a video link. So it sets out that witnesses or appellants who are abroad may wish to give evidence in administrative tribunals such as immigration, asylum or tax, and may want to submit evidence by a video link. And so it essentially directs you to this. You go through the steps. You essentially need to provide information such as which tribunal you wish to give evidence to, the countries from which you wish to give evidence from, and potentially pay a fee, that being a fee of £150 to conduct that search, and you then be provided with permission. So again, this format and process of seeking that permission and proceeding on that basis doesn't expressly outline this is what you need to do if you're in an employment tribunal, but equally it is a process which can be applied to witnesses and used for witnesses who are giving evidence in an employment tribunal. I've not myself had a case yet where an individual's gone through this process. However, a colleague in Chambers has, and they went through this process, got the permission and turned up to the employment tribunal first day of the hearing with that permission, and they're informed that the employment judge essentially just gave it a nod and said, well, that's good then, we can proceed, but didn't necessarily make any comment as to whether, well, if you hadn't have had this permission, we wouldn't be able to proceed, or indeed suggesting whether or giving any view on the permission one way or another. And that leads us on to, well, how is the tribunal dealing with witnesses abroad, specifically in relation to employment tribunals? So I've outlined that first particular instance of an individual who did go through the guidance following Agi Babaka and applied through the government website for that permission. But what I've also seen in another case of mine, when I had a witness giving evidence from California, was the judge essentially asked the claimant witness to agree at the outset of the hearing that they were happy that they were complying with all local laws and regulations. So essentially just put the onus on to the witness to orally confirm that they were happy with that position before proceeding. So that seemed to be somewhat of a middle ground compared to the process, the formal permission process that the government website sets out. But then I've also had cases where it was apparent to everyone in the hearing that the witness was giving evidence from abroad. Indeed, there was an interpreter involved as well. And no discussion was made whatsoever as to whether permissions ought to have been sought. So the hearing went ahead and nothing was essentially said. So we seem to have sort of three approaches going forward. And so in terms of answering how to deal with this going forward and what we should be doing, My sort of, and again, I'll caveat this with this is my opinion, and of course everyone else may have different opinions on how to deal with it. But I would first of all say check for recent presidential guidance on the topic. We are expecting guidance on this, given the recent guidance given to other administrative tribunals and courts in general as to how the ET approaches this. So check for that guidance. If we don't yet have that, or there isn't any guidance to the contrary, one way or another, my next top tip would be communicating with the witness in question that's intending to give evidence from abroad. It may be the case that that witness is familiar, having worked in that country or area they're giving evidence from, that they're familiar with the local laws and regulations, and they may indeed be comfortable with saying and confirming that they're happy to take that onus on themselves and happy to make a confirmation to the tribunal that they're content to proceed and they don't believe they're contravening any local laws or regulations. So I would say that would be the next step, but also making a early indication to the employment tribunal that you have a case whereby a witness is going to give evidence from abroad, and where that is and details of such, and equally with the opposing party in your case, and see whether any particular issues are taken from them. And if it's the case that the witness simply isn't sure what the position should be, or indeed you feel that's that's a burdensome request to put on them, then it may be the case that you want to go down the formal permission route, checking via the Gov website whether there has been express permissions put in place from that particular country already, or what the position is in that regard. Therefore, following on from that, in terms of how to deal with objections, either raised by the tribunal in terms of concerns, or by your own witness or the opposing party, in terms that goes back, I would say, your start points, the provisions we do have in place, and essentially there's nothing in the employment tribunal rules and procedures preventing or expressly prohibiting a witness from giving evidence from any given country that they may be in. And in fact, if we look at the overriding objective and the early rules, it's silent in most respects, apart from saying, well, look, we want to be able to deal with the cases justly, fairly, and as long as the individual can be seen and can be heard, all is fine. That's, in very basic terms, what the tribunal rules sets out the position to be. So I think you'd be on a fairly good footing, start point, in being able to argue that there's nothing expressly prohibiting your witness from giving evidence from another location. And indeed, it would be in line with the overriding objective to allow that to continue. So again, presidential guidance is expected on this topic in terms of what the actual position should be going forward. And like I've said, I've seen it dealt with in various ways in the tribunal. And in that regard, we're also interested in hearing your views. I think our screen is on a format whereby we can't actually hear or see you at the moment. But I'd be interested in hearing if anybody does have cases where they've got witnesses giving evidence from abroad, or have had instances, and what their experiences have been. Like I said, I've had 3 scenarios, essentially. One where they did get permission expressly, one where they just asked the witness to affirm that they were happy, and another where nothing at all was, no issues at all were taken, and the case just proceeded. So let me just have a look now as to whether.
Well, yes, Amy, there's a question in the chat, which says, I'd be interested in your views as whether this process applies to witnesses who reside in England and Wales, but might be on holiday, and also witnesses who live abroad. We've got a case with the latter, and we've been directed through a number of people, essentially to the Foreign Office, to the Italian Central Authority via the Hague Convention. I think that maybe typifies some of the confusion that not only practitioners have, but judges have, and there seems to be a widespread lack of certainty around this. Dead end so far. Grateful for any guidance.
Yeah, I don't, from what I've read and seen, there isn't any distinction taken in terms of sort of nationality or where the individual may have resided from. The only distinction taken from and set out within the ET rules and procedure is it making the distinction of those outside of Great Britain at the time of giving evidence. Yeah. So I don't think it would make a material difference whether it's the situation that they're on holiday in another country or they are going back home to another country. I think that both those types of individuals would be in the same position. But in terms of where you go with it, I think we've just got another input there as well. In terms of where you go with it, though, I don't know, I can see it's Zoe that's raised it, whether anything's been directly raised with the Employment Tribunal itself, and what I know sometimes they can be very hard to get hold of, depending on where you're listed out of. But in terms of what is it that the tribunal judge and the hearing's actually going to expect from you? Because, like I said, some cases, some judges I've had, they don't bat an eyelid, and you could essentially proceed with the view, well, it's in line with the overriding objective that we press on, and because there's nothing that, although again, I caveat it with, I completely appreciate that you want to press on at an early stage and try and get clear guidance on it. I'd be the same, but if it comes to it, and that's prohibiting in the Employment Tribunal your witness from giving evidence from another location, so I think that would be your ultimate backstop. But I would certainly try and get some form of answer. I think it's really hard through, as you pointed out, Zoe, through that process, dealing with the taking of evidence unit and dealing with, there's all sorts of delays and backlogs in terms of trying to get it.
I think that must be right. I think that must be the primary position, that they should be contacted within that 8 weeks. And I think the taking of evidence unit has to be explored within that procedure, because as essentially, I think Zoe set out that the tribunal did postpone the original hearing in that case.
Yeah, I've seen that.
Some judges perhaps seemingly are alive to it, and some maybe aren't at all. I know I've had cases where all the witnesses gave evidence out of Poland, and no one said anything. Everyone just continued as if they'd just been around the corner. The sort of belt and braces approach is that one could continue and essentially hope no one notices and argue the overriding objective, argue the backstop. But it may well be the case that tribunals postpone hearings as a result, which no one really wants to have. There's obviously cost and time associated with that. Amy, can you recall, you mentioned the colleagues case where this arose. Can you recall how that issue actually came to light?
It came to light, I think, so it was the respondents' witnesses that were abroad, but they had moved abroad, and it came to light because as part of their business they'd been doing other court proceedings in other jurisdictions. It was at commercial court matters as part of their business, and they'd been conducting those from residing abroad. So it was actually from them, the witnesses themselves, that had said, well, hang on a minute, we had to get special permission for these commercial proceedings. And it was actually the witnesses that had raised it. And it was the witnesses that then went down the route of the taking evidence unit, as they had done for the commercial matters, and seeking permission specifically for the employment tribunal as well.
Okay.
So that's how it was raised in that case. It was never actually raised by the tribunal. But I've just seen as well helpful comments from Nabila in the chat, indicating that the West Midlands ET sent a circular out on the issues about it. So that might be worth taking a look at, Zoe, and also I'll be interested in taking a look at that, because I've done a lot of research on this. I did have a case coming up where I'd had the same situation of another witness giving evidence from abroad, but it's settled now. So that's somewhat stopped me in my investigatory tracks. But it was, I had sort of got to the same point as you, Zoe, in terms of trying to get this permission out, and it seems that permission's given in quicker and swifter in some cases than it is in others.
Yeah, I think it may well be something that, until we get the presidential guidance, it's just worth practitioners just being alive to and being aware of, because I know when CVP started 2 years ago, it definitely wasn't something that was in the forefront of my mind when these issues were arising, because people just, of course, came to tribunal to give evidence. So I think that's the first thing to say. And secondly, it may well be that that circular from the West Midlands ET, maybe that's something that attendees here might want to look into, and that might give some insight into how they're dealing with it in the West Midlands, but also it might be an insight into what the presidential guidance might say.
Yeah, because Nabila, I see that you referenced the first and upper tribunal case there again, and that seems to be the most up-to-date guidance we've got, which is that you need to go and get this permission. Yeah. However, it is silent on the specifically the employment tribunal, and doesn't specifically pick that tribunal out. So, and the ET don't seem to have said much about it thereafter. But we did, you might have all been notified this morning, get from presidential guidance from the ET in relation to a roadmap over the next 2 years. I looked at that to see if it had any mention on the topic. It didn't, but it certainly outlines that over 2022 and 2023, that video hearings will remain. So in light of that roadmap that's been given this morning, I think this is an issue that is cropping up more and more, as per your experience and our experience, and it's an issue which the presidential guidance is going to have to turn its head to, I think, whether that be, okay, we all must follow the guidance that was given in the first tier and upper tier tribunals for asylum and tax and administrative tribunals, or, well, we've got our own process and you don't have to follow that. It'll be interesting to see what they do. But yes, it's frustrating, and it's frustrating going through the steps and hurdles from the taking of evidence unit, and also the fees that are imposed on individuals in terms of doing that as well, and the time and resources.
I've seen Victoria's helpful question about whether we can essentially find that document and circulate it, and I'm happy to, I'm sure Amy is as well, see if we can find that document online or somewhere else, and if we can, and it is a public document and we're essentially entitled and it's appropriate to share that, we'll see if we can get a hold of it and provide some copies to attendees. As we say, it might give a bit of an insight into this issue.
Yeah, and Zoe, apologies, can't be any more helpful as to as to your queries and where you've got to at your dead end. But I think it's the answer there on your specific case, because the tribunal's essentially postponed it, is going to be any attempts you can to continue down that route with the taking of evidence unit until any further advice or comments are made by the tribunal. I mean, presumably, if it's continually being postponed and adjourned, the tribunal is going to have to take the reins at some point and deal with that. I appreciate that's not the best or helpful guidance, but I think it seems that that's the only way to continue on yours, and hopefully they do give us some commentary and further guidance soon.
Thank you everyone very much for joining. I'm conscious of the time, so it's much appreciated. Hope it's been useful. As we said, if we can get that document and share that, we'll seek to do so. So thank you very much from me.
Thank you very much from me as well, and I apologise again for my dog's enjoyment during our webinar. So apologies for that. But thank you, and hope to speak to you all soon.
Thank you. Good afternoon.